Hey guys, Toby Mathis here, and today we're going to go over the top 5 estate planning mistakes that could cost you everything. And what I'm really trying to get into is common things that people do and they don't realize the ramification of. And so I'm just going to hit them 1, 2, 3, 4, 5 to make sure that you know, and you can kind of do a mental checklist as to whether any of these apply to you. Number 1, and I'm just going to put top 5, boom, and I'm just going to say this: the wrong beneficiaries on plans and life insurance. Okay, so what happens? What am I talking about, the wrong beneficiaries? I'm talking about naming an ex-spouse or somebody that, for whatever reason, you did not, maybe you're estranged, maybe it was somebody that you were close to at the time that you got the product, and you forget that you have them named as a named beneficiary. The most common example is when you have an ex-spouse. And I've seen this over and over again where somebody will unintentionally keep a financial tool like life insurance and have somebody named thinking, oh no, it's going to go to my estate, it's going to go to my kids, or it's going to be handled in my trust or whatnot. But they have a named beneficiary as a successor on either a plan document or on a life insurance product or some financial product where there is a named beneficiary. And if you have the wrong one, you don't get a do-over. You're not going to get, in some states, they have some laws that'll do some corrections. But in most of the cases, no, it's going to end up going to that recipient. And besides, we want to be very precise about how we're handling our estate. When you do your estate plan, you don't want these loose ends dangling around. So if you have 401ks, IRAs, if you have life insurance, annuities, and things like that, you want to review with your professional who the beneficiaries are and make sure that they're the correct beneficiaries, especially if you do have gone through a divorce, or if you have folks that you were close to that are gone, or you just want to make sure that it's going to the right place. So that's number 1. Number 2, seen this way too often, accidental disinherit. So what does it mean to accidentally disinherit somebody? That is when you have generally split families. So you have kids from a previous marriage, you get married again, and you don't intend to disinherit your kids, but the way that you allow your estate plan to progress is it's a straight transfer to the surviving spouse, and then they remarry at some point in the future, or they create an estate plan that nixes out your kids. So if you are a second marriage where you have kids from a previous marriage, you want to make sure that your estate plan actually addresses who receives your estate. And quite often, like in my planning, when we're doing living trust for the most part, you're going to be putting in there something called a Q-tip provision, which allows the surviving spouse to be the beneficiary during their life and then going according to your plan documents to your children. And it becomes irrevocable when you pass away or when you're incapacitated. That's really important, is that you don't want this thing to be subject to change. And I'll give you a horror story, and this is true. It was a gal who had cancer, passed away. Her husband had been carrying on an affair. The kids found out about it after mom had passed away and were very upset. And dad, well, he ended up getting married to that individual. They were very upset. And so it caused family strife, and dad said, I'm going to disinherit you guys. I'm going to leave everything to the new spouse. Do you think mom would be okay with that? Do you think that mom would be okay with dad, who was carrying on an affair during their marriage, disinheriting their children? No. So the way around this is with planning to make sure that you do not accidentally disinherit. And it can be so easy. Like under most state law, you're going to have a situation where somebody passes away, their spouse keeps it. So that happens, and then they get remarried late in life, and they're not really thinking about the fact that, oh my gosh, my estate, it might be family heirlooms and things like that, are going to go to my new spouse if I predecease. They're just not even thinking about it. I see it happen all the time. So I know this is something that we have to be careful about, because it's not what you intend. You'd rather have your family heirloom stay in your family. Maybe it's going to a sibling, maybe it's going to an aunt or something like that. You have to be very specific in your estate plan. So that's number one, or number two, accidental disinheritance. Number three, failing to plan for tax. And I'll just say taxes. Just saw this in Yellowstone, right? That was like one of their big, in the finale, right? They're losing the ranch because the estate taxes are so huge. It doesn't happen that often. It used to happen a lot more than it does now because the estate tax exclusion used to be, when I started practicing, was $600,000. Now it's, a really high amount, over 13 million. But that amount could be adjusted. That amount can go down. And if you are not careful, if you have a large estate, the amount of tax could cause the actual inheritance to be put in jeopardy. In other words, if I have real estate, we lived through this in 2008, 9, and 10, right? Somebody would pass away when the market was high, like 2007, before the crash. A year later, they pass away, and the property is worth a lot less. Maybe it hasn't come down like crazy. And then a year after that, when they're actually disposing of the estate or they're doing the taxes, probably more like 9 months, right? It's gone down even farther. And all of a sudden you're like, holy kashmoli, they're being valued up here. But if we sell it, it's down here. Well, the IRS doesn't let you have much of a do-over there. There is a tiny bit of relief. But what will end up happening, especially when you have a probate that might go 3 or 4 years, there's somebody that would have started at the beginning end of the recession, and then when they're actually liquidating and having to come up with the cash, they're 3 years into it. It's like, holy kashmoli, what am I going to do to create that cash? They're going to have to dispose of the asset. Well, they don't say, hey, it's what you actually sold it for. It's what it was valued for at the time of passing. So again, there is some relief 9 months after, but for the most part, you are stuck with that valuation when that occurs. And if you don't plan for it, like, how am I going to have liquidity? This happens with businesses, it happens with real estate. What if I have to come up with a tax bill? And it may not even be huge. I may have an asset that is included in my estate. And by the way, we're talking 40% tax here. So let's just say I end up with $5 million that's subject to tax. 40% of that's $2 million. How am I going to come up with the $2 million? Now, a lot of planners are going to say, hey, let's do some planning to keep that down. Maybe we do some gifts. Maybe we do some life insurance, but you want to be getting out ahead of this if you have a sizable estate. Plan for those taxes. Plan for even things like the cost of probate, burial costs, things like that. But I see the big one is failing to plan for taxes. That's the one that can knock you out. And then even if you sell, hey, I have an asset valued at $5 million, but on a fire sale, it's getting 4. My tax is still $2 million. I just lost, 60% of my estate value by accident. So don't do that. Number 4, joint ownership. I see people do this with their kids. I see people do this with their spouses, where they have joint ownership with right of survivorship. Or they just have, hey, I'm adding my kid onto my account, so it's joint ownership. And what ends up happening is, I see this over and over and over again, so just trust me on this one. Parents do that, and then they say, I'm going to have the responsible child that's on the account with me, and they'll take care of their siblings. It doesn't happen that way, guys. There's always something that ends up getting into the mix, always ends up being contentious, or more often than not. I guess there's some families that we don't hear from that are handling it well, but a lot of them, it's like, whoa, once one kid's on the account, there's $1 million account, mom passes away, dad's passed away 10 years ago, child now has $1 million. They had already had it gifted to them during their lifetime. That's the rub. You could even have tax issues on that, right? But let's just say you put them on joint tenants with mom's account. Now that's their account. And then they say, hey, you're going to take care of your brothers and sisters. And they go, no, I got $1 million. Why would I do anything? It's their money. The other side to joint ownership, that's a little bit of a dirty secret people don't want to realize. You put your child on your house or on your bank account, their creditors become creditors of that asset. In other words, they can collect against that asset. Seen this one. Mom puts oldest son onto bank account. Son's creditors immediately start garnishing that account. And mom says, whoa, 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 whoa. Son never said to mom, hey, I have some financial issues. Mom finds out by having a big chunk of her estate disappear and unbeknownst. So that joint ownership is another one. I just say don't do it. There's something called a step up in basis. When you pass away, the value of your assets for tax purposes goes up to the fair market value, which means its basis moves up. So in English, if I bought stock for $100 and now it's worth 1,000, when I pass away, my new basis is like I bought the stock for $1,000. So if my kids inherit that stock, they pay no capital gains if I let it pass to them after I pass. If I put them on the stock, my basis is their basis. So if I put them onto the same situation, their basis becomes my basis. So whatever I gave it to them at is the basis, whatever I gave it to them at, my basis on whatever I gave them, they're getting that basis going through. So they lose the step up in basis. So in English, I give them a share of stock that I bought for $100. Their basis is $100. Now, if I pass away, it's still $100. So if it's now worth $1,000 and they go sell it, they're paying capital gains on $900. That would have been avoided had I just done it like through a living trust. That's usually the solution on these things. And then number 5, no will or trust. Now, I'm going to say I want that trust. We're always going to have a will, no matter what. Even when we have a living trust, we still have a will. It's called a pour-over will. Dumps the assets back into the trust, no matter what, in case we don't have funding of the trust. But no matter what, we got to have a written plan of where it goes. Otherwise, guess what you have? You have the situation that happened with Prince, right? Where you're going under state law and everybody, it just ends up being a long, drawn-out, expensive process that usually depletes most estates. It's called intestate. It's not a plan. Not having a plan, not a good plan, right? So my preference would be to have a trust. A secondary preference would be to at least have a will. A will still requires probate, where a trust does not. So what is probate? It's a court-ordered process to distribute assets. So I need a court order to say who's the new owner. If I'm using a will, I have to go through that probate process. When you don't have a will or a trust, you go through the probate process. The only one that avoids probate is using that trust. That trust, I don't need the court order anymore, so I can avoid having to go to court. So we want to avoid court if we at all humanly possible, so that trust becomes our friend. But at a minimum, make sure at least you have a written direction, at least to have that will, and don't leave your heirs to have to fight over things under the statutes of the state where you resided when you passed. Or where the asset is. Like if it's real estate, even the worst part is that unless you have an estate plan like a trust, or you're using LLCs in conjunction with your estate plan, you are probating in every single state that you own real estate. And when I say you, it means your heirs are doing it. You just left them a mess. So if you don't have a will, or you do have a will, but you have real estate, you are probating in every state where that real estate is held. Again, the only way out is through the use of trust or an entity in conjunction, right? We can use LLCs and things like that to at least limit the probating into the state where I reside when I have the will. But at the end of the day, what I really care about is that we avoid all that. We keep our estate private, and that we keep the expenses down. Because when you end up with a contest in an estate, it will drain that estate quickly. When you have lawyers on multiple sides, let's say you had 3 kids and they're all lawyered up, they're all fighting over the Christmas plates, they're fighting over the house, they're fighting over whatever assets you left behind. Those lawyers are getting paid. The court is not cheap. Experts are not cheap. Appraisals are not cheap. You're going through a whole process that's now going to deplete your estate, and that can cost you everything. So those are the top 5 things that can, planning mistakes, that can cost your estate everything, cost you everything. And let's make sure that you don't make them. Hey, if you have any comments or you have any suggestions, please put it down below in the comment section. Like and subscribe, and if you know anybody who would benefit from this, please share this.